So Amy Coney Barrett is officially a Supreme Court justice. The vote was mostly down party lines. I think it was actually completely down party lines. 53 votes in favor. We used to have the filibuster, and they would have needed 60 votes. Now we no longer have the filibuster, and so she got on with 53 votes. As a result of that, there's a lot of misinformation out there. There's a lot of people on social media saying, well, I mean, there's literally nothing the Democrats could do, so, like, we can't be mad. But that's just factually wrong. There was plenty that the Democrats could have done, and they chose not to do it, and they chose not to do it simply for political reasons, namely the upcoming election. They made a calculation that, hey, if Amy Coney Barrett gets on the court fast, then, you know, you saw it last night. The second she was approved, it was like in unison, every Democratic politician that I follow, and I'm sure a lot of the ones I don't follow, tweeted the same thing at the same time about, well, I guess you got to go vote. I guess you got to go vote. See, I mean, see what happens? See what happens? This is when Republicans win. This is what happens. So what do you want me to tell you? The only solution is to go vote. Now, I'm going to explain to you why that argument in this instance is actually one of the dumbest arguments I've ever heard in my life. Because people who say that really have no understanding of how significant and colossal this occurrence was. So Amy Coney Barrett getting on the court is not just another standard Democratic loss, which we're kind of used to at this point. Amy Coney Barrett getting on the court is really a stake through the heart of even the idea of the most minimal positive change you can imagine. So first of all, let me tell you what the Democrats actually could have done, what they could have done. There's a bunch of things they could have done, but so I'm quoting from Jacobin here. This is an article that came out, I believe, in late September. They say, for instance, they could have insisted on short-term, week-by-week budget bills to grind the process of passing appropriations to a crawl. House Speaker Nancy Pelosi had that option, but took it off the table. She took it off the table. By the way, this one isn't even a difficult thing to do to jam up the process. That's not even difficult. She immediately took it off the table. Ask yourself why. However, House lawmakers could also pass other measures, such as articles of impeachment or war powers resolutions, that would automatically be prioritized on the Senate schedule under existing rules. In the Senate itself, the memo says Democratic senators should explore filing so-called fast-track measures that could also take precedent on the Senate schedule and push off a court confirmation vote. I've already given you like 3 things they could have done, 3 separate avenues to go about jamming the process. Again, they didn't do it. Ask yourself why they chose not to do it. So the memo says, this was a Democratic memo that was floating around in D.C. where they were explaining, hey, here's a bunch of ways, if you really wanted to, you could stop somebody getting on the court. Several fast-track statutes, including the Congressional Budget Act, the Congressional Review Act, the War Powers Act, and the Arms Export Control Act, give any senator the right to move to proceed to a vehicle and force a roll call vote and sometimes a period of debate. For example, any senator could submit a concurrent resolution on the budget, and by precedent, if action has not yet been taken on a budget resolution for the coming fiscal year, then the resolution would be immediately placed on the calendar. Once on the calendar, any senator could move to proceed to the resolution, forcing a roll call vote on the motion to proceed. Meanwhile, resolutions of disapproval under the CRA can be petitioned out of committee with 30 signatures after 20 calendar days. Such measures could be filed in mass. Is that how you say that? In mass? In mass? I don't know how you pronounce that. Here, I have more for you. The elimination of the supermajority requirement to break filibusters of Supreme Court nominees has left the minority party with limited procedural options, but that's not to say there are no options other than trying to persuade Republicans that the political consequences of pushing ahead with Trump's nominee could outweigh the benefits. Again, this is still from Jacobin here. Since the chamber largely runs on unanimous consent, any Democratic senator could, for instance, gum up the works of the Senate by objecting to everything else McConnell wants to do, forcing Republicans who are up for re-election to spend additional time casting procedural votes. The Democratic minority has generally gone along with unanimous consent agreements, setting up predictable schedules of votes, especially on many of Trump's judicial nominations. Democrats could also seek to enforce a Senate rule barring committees from meeting past the first 2 hours of a day and objecting to all kinds of routine business, from the naming of post offices to the declaration of holidays. Another option could be moving forward with impeaching Attorney General Bill Barr. As Business Insider notes, impeachment would compel the U.S. Senate to hold a trial at a time when it has precious few days left on the calendar to confirm a replacement for Ginsburg. By the way, another thing that Nancy Pelosi could have done, she could have leveraged a government shutdown. She chose not to do it. So, the point here is, they had many things they could have done to jam up the process. They didn't do any of it. In fact, it was the opposite. They had a hearing, it went through, it may have been record time, and now Amy Coney Barrett is on the court, and they instantly go out there and try to fundraise off it and try to pump up voter turnout. Now, here's the saddest part of the conversation. It breaks my heart to tell you this part, but I have to tell you because it's true. With a 6-3 conservative court, here's the way it works. The Supreme Court has the power of something called judicial review. And the idea behind judicial review is, hey, you can't have the legislative branch and the executive branch basically do whatever the hell they want. You need to have a judicial branch that provides checks and balances. And the ruling in Marbury versus Madison was effectively that the judicial branch can determine whether or not something done by the other branches of government is constitutional or unconstitutional. And so they can come up with some sort of argument, reference the Constitution, and say, hey, that legislation that you just signed into law is not allowed to be signed into law because this is overridden by the Constitution, and the Constitution is the supreme law of the land, and the Constitution does not allow for you to do what you just did in this legislation. So, when you have a 6-3 conservative court, this isn't hyperbolic, this isn't exaggeration at all. What can happen, and what likely will happen, is even if you get a Democratic president, even if you get a Democratic House, even if you get a Democratic Senate, even if it's a supermajority across the board, let's say, for example, they get their act together and they pass a $15 minimum wage. Great, right? Let's say they get their act together and they expand Medicaid and cover millions more people with health insurance. Great, right? Then you'll have lawsuits over that legislation. They will work their way to the Supreme Court. The Supreme Court will look at them and say, we think a $15 minimum wage is unconstitutional. We think expanding Medicaid is unconstitutional. That's what we think. We think even minor, incrementalist, baby step changes in the right direction, we think it's all unconstitutional. So, in other words, for Democrats to let Amy Coney Barrett get on the court and then say, vote afterwards. Do you not understand what just happened? You've made it so that the vote means a hell of a lot less if anything the Democrats do that's positive can get struck down anyway by the court. That's why you had to fight on Amy Coney Barrett, to save the possibility of getting even minor change done. Are you out of your mind? And I think the reality is, a lot of Democratic politicians, they just don't know how the system works. They don't know how powerful judicial review can be. And they're certainly not familiar with the history of the Supreme Court. Because you're watching me right now and you might think, hey, Kyle, maybe you're being a little over the top here. Is this really how it's going to unfold? It already has in the past. There was an era of Supreme Court history known as the Lochner Era. And in the Lochner Era, the Supreme Court ruled that basically there's this thing called a right to contract in the Constitution. And what that means is a business owner and their employee, when they develop a contract, the government cannot step in as an independent third party and say, hey, those terms aren't fair. Hey, you got to pay more money. That doesn't line up with the minimum wage. Hey, you can't have child labor. We have child labor law protections. Hey, you can't dump that toxic material in the river because that's, violating environmental laws. The Supreme Court ruled in the Lochner Era that there's a right to contract between business owners and employees, and the government needs to butt out. So they codified what is basically a free market fundamentalist society, where they said, child labor laws, we think a lot of them are unconstitutional. Minimum wage laws, definitely unconstitutional. Overtime pay, you can't force businesses to pay overtime pay to their workers, totally unconstitutional. So it was basically an entire era of the Supreme Court that made any positive economic change impossible. It was only in the mid to late 1930s that we finally flipped the balance of power and got some decent decisions out of the Supreme Court, who then allowed the government to do basic positive reforms, like in the New Deal, for example. And so they allowed the government to actually play a role in our economy to have better outcomes. But up until, I think it was from the late 1800s until the 1930s, we had a Supreme Court that wouldn't allow even basic marketplace regulation, basic labor protections. And now you have a 6-3 conservative court. We may have casually just slid back into another Lochner era, and the Democrats didn't put up any fight at all. And now they have the nerve to tell you to vote, either probably not even understanding what just happened. Go ahead, vote as much as you want, and then sit back and watch the Democrats get minimal positive change with 0 Republican votes. It all goes to the court slaps down all of it, and then the Democrats will turn around and feign shock and outrage. Oh my God, how could they slap down these things that we did that were minorly positive? Because you didn't fight on Amy Coney Barrett. You didn't fight. Now, final point is, they might throw us a couple bones on some social issues and dupe the idiots in mainstream media into thinking they're a moderate court. You know, maybe they'll say, okay, Roe versus Wade, fine, it's constitutional, whatever. Every now and then they'll throw you a bone on a social issue or two. But the bottom line is, they're very likely to always side with giant corporations. The Democrats could have done something to stop it. They didn't do it. And now, I'm not kidding when I say the progressive movement is in the worst place it's been in my entire lifetime.